The Arizona Civil Rights Act, ARS, Section 4-1-1491 through Section 4-1-1491.38, is more than a legal framework. It is a living standard that shapes how real estate professionals interact with clients, manage transactions, and promote equality in housing. Applying this law in real-world scenarios requires not only knowledge of its provisions, but also sound ethical judgment. Real estate licensees are expected to recognize potential violations before they occur and to take immediate corrective action when discriminatory behavior or practices are observed. Understanding how the Arizona Civil Rights Act functions in daily real estate practice ensures that agents protect both consumers and their own professional integrity. To apply the Arizona Civil Rights Act effectively, real estate professionals must first understand how discrimination might appear in practical settings. Discrimination is not always overt. It can be subtle, unintentional, or even result from ignorance of the law. A clear example involves steering, where an agent might direct clients towards certain neighborhoods based on their ethnicity or family structure. For instance, if a salesperson says, "This area is mostly young families, you'll probably feel more comfortable here," the agent has made an unlawful statement under ARS Section 41-149-1.14, which prohibits actions that limit housing choice based on protected characteristics. Even if the comment seems harmless, it still constitutes a violation because it implies that clients should live in areas based on their identity rather than their preferences. Another real-world example involves reasonable accommodations for individuals with disabilities. Suppose a landlord refuses to allow a tenant with a service dog to move into a no-pets apartment complex. Under ARS Section 41-1491.19, this refusal violates the tenant's right to a reasonable accommodation. The landlord's policy must yield to the tenant's needs, as service animals are not considered pets under the law. The same principle applies when a person with mobility impairments requests permission to install grab bars or ramps at their own expense. Denying these modifications would violate fair housing law and could lead to penalties enforced by the Arizona Attorney General's office. Discrimination can also occur in advertising and marketing, a common area where licensees may inadvertently violate the law. For example, a property listing that states "perfect for single professionals" or "ideal for Christians" would violate ARS Section 41-149-1.15, which prohibits discriminatory advertising. Such wording expresses a preference or limitation that discourages people of certain classes from inquiring about the property. Ethical real estate professionals must review every marketing material carefully to ensure that advertisements are neutral and inclusive. Words like quiet neighborhood, close to schools, or family-friendly are acceptable when describing a property's features. But any suggestion of preference for or against a protected group is unlawful. Consider also a situation involving familial status discrimination, where a landlord tells a family with children that an upstairs unit is unavailable due to noise concerns, yet rents that same unit to adults without children the following week. This would be a clear violation of ARS Section 41-149-1.01, which protects families with children under the age of 18. Arizona law presumes that every family deserves the same access to housing opportunities unless the property qualifies as housing for older persons as defined by ARS Section 41-149-1.04. Even failure to act can constitute a violation. If a property manager becomes aware that another tenant is harassing a resident because of their disability, religion, or national origin, the manager has a legal duty to intervene. Ignoring or dismissing complaints of harassment may result in liability for both the property owner and the management company. In HU D.V. Rutledge, 2002, a similar case under federal law A landlord was held liable for failing to address harassment between tenants. This same principle applies under the Arizona Civil Rights Act, which prohibits discriminatory conduct and retaliation under ARS Section 41-149, 1.21. Applying the Arizona Civil Rights Act also extends to how brokers manage their offices. Designated brokers must ensure that all agents under their supervision are trained in fair housing compliance. Under R 4-28-1103, brokers are responsible for establishing written policies and providing ongoing education to prevent violations. For example, a broker who allows agents to post discriminatory ads or make unverified statements about neighborhood demographics could face ADRE disciplinary action under ARS Section 322153 for failing to supervise. Implementing office-wide fair housing training and reviewing marketing materials regularly helps maintain compliance and protects both the brokerage and its agents. Let's examine a few brief, real-world scenarios and how the Arizona Civil Rights Act applies. Scenario: a landlord refuses to rent to a same-sex couple. This violates local ordinances in cities such as Phoenix, Tempe, and Tucson, which prohibit discrimination based on sexual orientation and gender identity. Even though these are local protections, the ADRE can still discipline the licensee for unethical conduct under R 4-28-1101 for failing to treat all parties fairly. Scenario: a real estate agent discourages a Hispanic buyer from purchasing in a specific neighborhood, saying, "You might not fit in there." This statement constitutes steering based on national origin and violates ARS Section 41-149, 1.14. The agent could face both state and federal penalties for discriminatory conduct. Scenario: a property owner denies a tenant with multiple sclerosis a parking space closer to their unit. Denying reasonable accommodation violates ARS Section 41-149, 1.19, which requires landlords to adjust policies to accommodate persons with disabilities. In each of these examples, the Arizona Civil Rights Act requires that housing decisions be made based solely on legitimate, non-discriminatory factors, such as income, creditworthiness, or rental history, not on personal characteristics. Real estate professionals must use consistent, objective criteria in evaluating clients and transactions to avoid both the appearance and reality of discrimination. Review summary. Applying the Arizona Civil Rights Act, ARS Section 4, 1-149, 1 ETCQ to real-world scenarios means recognizing how discrimination occurs in practice and taking proactive steps to prevent it. Violations may include steering, discriminatory advertising, refusal to make reasonable accommodations, or denying housing based on familial status. Licensees must treat all individuals equally and ensure that all decisions are based on lawful, objective criteria. The Arizona Attorney General's Office investigates violations, while the ADRE enforces ethical and professional conduct standards. Compliance not only prevents legal penalties, but also upholds public confidence in the real estate profession. Discussion: how can real estate professionals prevent fair housing violations in daily practice? Answer: by using objective, non-discriminatory criteria when working with clients, avoiding biased language, providing reasonable accommodations, and maintaining awareness of both state and local fair housing laws. Why is discriminatory advertising considered a violation of fair housing laws? Answer: because it discourages or excludes individuals from housing opportunities based on protected characteristics. Violating ARS Section 41-149, 1.15. What steps must brokers take to ensure compliance with the Arizona Civil Rights Act in their offices? Answer: establish written fair housing policies, provide ongoing training, review marketing materials, and supervise agents under R 28 1103 to prevent violations. Closing remarks. Applying the Arizona Civil Rights Act in real world situations requires more than understanding the law. It demands constant awareness, ethical decision making, and a commitment to fairness. Real estate professionals serve the public trust, and that trust is built on the promise of equal opportunity. By integrating the principles of the Civil Rights Act into every transaction, communication, and advertisement, Light and Z's help create communities where fairness, respect, and inclusion are the standard. Upholding these values ensures not only legal compliance, but also strengthens the reputation and integrity of the real estate profession across Arizona.